This is the Radical Transparency Podcast with your hosts, Marie-Louise Arnaud and Denis Lemaire.
Imagine this, a legal fight heating up right here in Quebec. You've got a research center funded by taxpayers, a citizen journalist raising alarms, and a lawyer who's so influential, he basically helped write the rule book on government transparency.
It really does sound like something out of a legal drama, doesn't it?
It does. And today we're doing a deep dive into this legal battle, which is, frankly, way more than just a standard lawsuit.
Yeah, it's shaping up to be a major test case. We're talking about government transparency, accountability, and maybe even the overall health of democracy in Quebec.
Exactly. We've got a pile of documents here, legal demands, investigative reports, expert analyses, all focused on this defamation case involving the Centre de Recherche Informatique de Montréal, or CRIM, and Pierre Côté's company, RTA Intelligence, Inc.
And our mission today, we want to unpack who this lawyer, Raymond Doray, actually is. Why was he specifically brought into this? And critically, what does it all mean for you, the taxpayer, and for how things work democratically here?
Okay, let's get into it. Where did this whole thing start? It kicked off with allegations from Pierre Côté and RTA Intelligence against CRIM.
Right. Back in July 2025, Côté posted something like 75 messages on CRIM's LinkedIn page. CRIM immediately labeled many of them as defamatory.
And it wasn't just LinkedIn posts, was it?
No, not at all. Around the same time, he also put out this investigative report. It looked into CRIM's public mandate and its obligations, supposedly, to support Quebec's innovation scene.
And the report itself, it had a certain air about it.
It did. It was framed as if it was prepared for the Quebec government. You know, the Premier's office, the Ministry of Economy, Innovation and Energy, the MAE.
Pretty official sounding.
Very. But here's the catch. Côté signed it as a lobbyist, and his company, RTA Intelligence, Inc., well, it had only been created a few months earlier in February 2025. And he was its only director.
Okay, so a bit of a mismatch between presentation and the underlying facts there. What were the actual claims in the report?
They were serious. RTA Intelligence accused CRIM of anti-competitive behavior, and maybe even more significantly, of diverting public funds.
Diverting public funds? How?
The core claim was that CRIM was using its public resources, its reputation, its researchers' time, paid for by grants, its brand, to basically give an unfair advantage to a private company called Technologia.
Like a cozy relationship.
Exactly. They called it symbiotic. The idea was that CRIM helped Technologia develop and market training courses, using public backing to give them a leg up.
And there were specific personnel links mentioned, too.
Yes, concerns were raised because CRIM's CEO, François Labonte, apparently sits on the board of Technologia Formation Conseil. That immediately flags potential conflict of interest issues, you know.
Right. And beyond Technologia, what else did RTA claim?
RTA argued CRIM was failing its broader mandate to help Quebec's innovation ecosystem, especially new AI startups. This is despite getting a lot of public money, over $13.4 million just for 2024-2025, and over $50 million total since 2017.
$50 million. Wow. Was there data to back that up?
RTA pointed to a statistic. Only 53% of the organizations CRIM actually served were SMEs, small and medium-sized enterprises. This, they argued, flew in the face of CRIM's mandate, which supposedly prioritizes SMEs.
So the argument was that smaller, innovative companies were being sidelined.
Pretty much. Côté alleged that promising startups, and he included his own ventures like Drellis.ai and Ocean.ai, were basically left behind because CRIM was too focused on established players in commercial deals.
Okay, so those are the accusations. How did CRIM respond? I imagine not quietly.
Not quietly at all. They hit back hard through their lawyers. They called Côté's claims extremely serious, saying they implied CRIM lacked transparency, misused funds, was maybe even corrupt.
Strong words. Did they address the mandate issue directly?
They did. CRIM argued their main job isn't just helping AI startups. It's about building custom tech projects with organizations of all sizes, SMEs and large companies, to reduce risk and speed up getting products to market. They essentially said Côté was deforming reality.
And did CRIM offer a reason for Côté's accusations?
Yes, and this is key. Their legal letters stated very clearly that the primary cause of Côté's vexatious remarks was that CRIM had refused to give funding to RTA Intelligence and its related companies.
Why?
Because, according to CRIM, Their projects just didn't meet CRIM's rigorous criteria.
So, sour grapes, basically. That's the implication.
That's definitely the implication CRIM put forward. Right. And their demands were stark. Stop the LinkedIn messages immediately and issue a full, self-written retraction within 48 hours to everyone who got the report. Or else
face legal action.
Exactly. For damages, including punitive damages, a serious threat.
Okay, this is where it gets really interesting, I think. The lawyer CRIM brought in, tell us about me, Raymond Doray.
Right. This is pivotal. CRIM hired me, Raymond Doray, Advocatus Emeritus, a senior partner at a major firm, Lavery de Billy. This isn't just any lawyer.
Advocatus Emeritus, that's a big deal in Quebec, right?
It's a huge honor from the Quebec bar, reserved for lawyers with truly distinguished careers. He's also been named Lawyer of the Year multiple times in administrative and public law. His expertise covers information law, privacy, defamation, corporate governance, government litigation, the whole package.
But there's something even more specific, almost ironic, about his expertise in this particular area.
Absolutely. This is the twist. Meade Doray is the author of the book, a massive, constantly updated 2,000-page legal treatise on access to information and privacy law in Quebec. He literally wrote the definitive guide on public disclosure rules.
He wrote the book?
He wrote the book. And his involvement goes back decades. He advised the Pareil Commission back in 1980, which was studying government information access. Oh, yeah. And then in the 80s, he advised the government's executive cabinet and the Commission d'accès à l'information, the CAI, the actual watchdog agency for transparency. He helped build the system.
So let me get this straight. The guy who helped design Quebec's transparency framework is now the go-to lawyer for institutions, potentially, trying to limit that transparency.
That's the paradox. He's the architect of access, but also, arguably, the most effective gatekeeper of secrecy when institutions feel threatened. His deep understanding of the system makes him incredibly potent when arguing against disclosure.
Looking at his track record, does this fit a pattern? Has he taken on similar roles before?
Oh, absolutely. His client list is basically a who's who of the Quebec establishment. He's represented the Quebec bar itself, the Order of Notaries, the Judicial Council. When powerful institutions face scrutiny, he often gets the call.
And not just representing organizations, but in major public inquiries, too.
Yes, that's telling. He represented a key player in the Gumry Commission, the big federal sponsorship scandal in 2005. He was involved in the Poitras Commission, looking into the Sûreté du Québec, the provincial police. And he was lead counsel for the Grenier Commission in 2009, which investigated alleged illegal spending during the 95 sovereignty referendum.
So he's like the establishment's crisis manager, the person you call when the institution's very legitimacy is questioned.
That seems to be the role he plays. His being hired by CRIM signals, they see this not just as a minor defamation spat, but as a serious threat to their reputation, needing top-tier crisis management.
Are there specific past cases that echo the current situation, maybe involving transparency or public funds?
There are, and they're quite illuminating. Back in 1997, there was a controversy involving the CAI itself, the Access to Information Commission.
The body he advised.
The very same. The CAI allegedly paid about $15,000 from public funds to a private society that Meade Doray presided over, reportedly to cover its deficit. This raised serious conflict of interest questions, given he argued cases before the CAI.
Okay, that sounds problematic. Any others?
Yes, the Cité de la Biotechnologie case. Another publicly funded body hired Meade Doray specifically to fight a journalist's request for access to information.
What information?
The director's employment contract and expense reports. Even the local mayor at the time publicly questioned using public money to fight transparency.
So these aren't just isolated incidents. You're saying there's a playbook here.
It certainly looks like a pattern. His expertise seems consistently deployed to shield entities, often public or public-funded ones, from scrutiny, especially when public funds or potential conflicts are involved. It suggests a strategy prioritizing institutional protection over public disclosure.
Which makes his involvement in the CRIM case.
It makes it seem less like a unique event and more like the latest chapter in a long story. He's defending against the very type of controversy involving public funds, transparency, potential conflicts that he himself has been adjacent to or involved in defending against historically.
Now, given this background and the nature of CRIM's legal action, the term SLAPP suit has come up. What exactly is that and why is it relevant here?
SLAPP stands for a strategic lawsuit against public participation. And several legal analysts and commentators are framing CRIM's lawsuit this way. The key idea behind a SLTP isn't really winning the case on its merits.
It's more about the process.
Exactly. It's about using the threat of incredibly expensive, time-consuming litigation to intimidate, censor, and ultimately silence critics, especially those with fewer resources.
What are the typical signs of a SLAPP suit?
Well, you often see a big power imbalance here, a government-funded research center versus a citizen journalist or small company. The issue being debated usually involves a matter of public interest, like how taxpayer money is being used.
Which fits this case.
Perfectly. And the demands are often extreme, like Crim demanding a self-flagellating retraction, as some call it, and immediate silence. The goal is to create a chilling effect, discouraging others from speaking out.
And you mentioned earlier that Cote actually offered Crim a chance to respond.
Yes. RTA Intelligence says they formally invited Crim's leadership multiple times to do a recorded interview, to give their side of the story. Crim apparently chose legal threats instead of dialogue.
Which doesn't look great if you're claiming the accusations are baseless.
It certainly undermines the position that they're open and have nothing to hide. Refusing to engage directly, then hitting back with overwhelming legal force. It fits the SLAPP narrative.
Is there any protection against these kinds of lawsuits in Quebec?
Yes. Quebec law actually has quite strong anti-SLAPP provisions. Articles 51 to 56 of the Code of Civil Procedure are designed specifically to allow courts to quickly dismiss abusive lawsuits that are clearly aimed at shutting down public participation and debate.
So bringing it back to Doray, why him specifically for this job, potentially a SLAPP suit?
It sends a powerful message, doesn't it? Hiring me, Raymond Doray, the establishment's cleaner, signals Crim is playing hardball. It leverages his immense reputation and implies they will use every legal tool and significant resources to crush this opposition. It's an act of intimidation in itself.
So the choice of lawyer is part of the strategy.
Absolutely. And it forces you, the public, to ask, what exactly did RTA uncover about Crim's funding? Its technology relationship that felt so threatening, it required bringing the ultimate crisis manager. What are they trying so hard to protect?
This clearly goes beyond just Crim and RTA then. What are the broader stakes?
Fundamentally, it's about public accountability. Can organizations running on your tax dollars turn around and use that same money to hire elite lawyers to silence you when you ask legitimate questions about how it's spent?
It sets a dangerous precedent if they can.
It creates a chilling effect across the board. If asking questions about public bodies leads to potentially ruinous legal battles, who will dare to hold them accountable, democracy needs watchdogs, journalists, citizens, whistleblowers. This kind of action scares them into silence.
And what about the legal profession itself? Does it have a role or responsibility here?
That's a critical question. Lawyers are officers of the court. They have a duty to justice that goes beyond just serving their client. If a legal demand is clearly being used not for justice, but as a weapon to silence public debate,
does the lawyer become complicit?
That's the ethical dilemma. The Quebec bar has actually condemned SLAPPs in the past. So this case is a real test of whether those principles will be upheld when one of its most eminent members is involved.
It's about the integrity of the justice system itself, in a way.
Precisely. Public trust in the justice system is vital, but fragile. Every time it looks like the system is being used to punish someone for speaking out on public issues, that trust takes a hit. Protecting that trust is a core responsibility of the Bureau.
So wrapping this up, we've peeled back the layers here. We looked at the specific fight between RTA and Crim, but crucially, we focused on the lawyer, Raymond Doray.
Yeah, his unique background as both an architect of transparency law and a defender of institutions facing scrutiny is central. His history, the pattern of his involvement in high-profile cases, it all adds context.
And it highlights this core tension, doesn't it? The clash between an institution wanting to protect itself, potentially using public funds to do so, and the public's right to know, to demand accountability.
That's really the heart of it. Can powerful entities use the legal system, bankrolled by taxpayers, to shut down questions? Or will the right to scrutinize how public money is used win out?
So the takeaway for you, the listener, understanding this complex interplay between legal tactics, public funding, institutional defense, and democratic rights, it's never been more important.
It really forces a choice, or at least highlights one facing Quebec. Is transparency going to be a core operating principle? Or is the fear of legal retribution going to be the price you pay for asking tough questions? Something to really think about.
This has been the Radical Transparency Podcast. Thank you for listening, and we encourage your continued engagement in democratic accountability. RTA Intelligence Inc. is committed to the highest standards of citizen journalism adhering to editorial principles established by the New York Times, PBS, BBC, CBC, AFP, Reuters, and Associated Press, as well as the Quebec Press Council Code of Ethics. These principles include accuracy and fact-checking, editorial independence and impartiality, fairness and right of reply, transparency and accountability, source protection, and separation of news from opinion. Our mission is to serve the public interest through rigorous adherence to these fundamental journalistic standards. This episode was produced using a collaborative approach that combines human editorial oversight with generative artificial intelligence. Human editors made all content decisions, fact-checking, and editorial judgments. AI technology assisted with research analysis and content structuring. All factual claims have been verified through multiple independent sources and are limited to publicly available information. We maintain complete editorial independence and have no financial relationships with any subjects discussed. All individuals and organizations mentioned have the right to respond to our analysis. We are committed to correcting any factual errors promptly and transparently. Our content is produced under the protection of Canadian Charter rights to freedom of expression and serves the democratic need for governmental accountability and informed public discourse. Any future projections or scenario analysis presented constitute hypothetical scenarios based on professional assessment methodologies and are not guaranteed predictions of future events. They are provided for educational purposes to inform public debate. RTA Intelligence Inc. expressly disclaims all liability and responsibility for any physical, moral, financial, or reputational damages arising from this episode. This content is provided for informational and educational purposes only. RTA Intelligence Inc. assumes no responsibility for decisions made based on this content. By listening to this episode, you acknowledge that any reliance on the information presented is at your own risk. This disclaimer is governed by Canadian law and Quebec provincial law. RTA Intelligence Inc. reserves all rights under freedom of expression protections and journalistic privilege. For corrections, responses, or editorial inquiries, contact RTA Intelligence Inc. We guarantee acknowledgement within 24 days and response to factual correction requests within 72 days. This content may be shared for educational and public policy discussion with proper attribution. Any redistribution must include reference to RTA Intelligence Inc. and disclosure of AI assistance in production. Thank you.